Thanks. It's really fun to be here. And I've got to start with the usual disclaimer, right? Everything I say is my view and not the view of the Department of the Interior or the United States government. That'll become obvious in a little bit here. Do you remember that thing in The Tonight Show? I saw it once when I was a kid. I was amazed by it. They had a juggler on a unicycle who was juggling a bowling ball, a wedding cake, and a chainsaw. And it reminds me of what's going on with oil and gas right now at the federal level. There's just a lot going on, right? There are so many topics. I'm going to breeze through them really fast because I take the opportunity you have to ask questions really seriously, and that's a better use of time, I think. So I'm just going to rip right into it if that's okay with you. In January, pardon me, in January of this year, BLM issued a new IM called Updating Oil and Gas Leasing Reform, Land Use Planning and Lease Parcel Review. You all familiar with that? It did a number of things, basically to do a reset on how we do leasing. It set some time frames, gave some discretion back to frontline managers, and to me, I thought from my perspective, it helps us manage the work of the department more efficiently, more creatively. And it will be used for the first time in Colorado for the December 2018 lease sale. The other big issue that's going on right now is lease cancellation issues and litigation surrounding lease cancellation. Are you familiar with that? Just down the road, right, is Roan Plateau, which was the subject of one of the biggest lease cancellations in BLM's history. And we did something similar at Thompson Divide with URSA's leases in 2016. And the really exciting thing or interesting thing from a legal perspective is we have two lawsuits pending out of Montana in an area called Badger 2 Medicine, where the question before the federal court in Washington, D.C. is whether BLM has the authority to cancel leases at all. Have you heard about this? And that's a pretty big thing because sometimes lessees will want to return leases and we want to cancel them. And the question becomes, well, if we don't have authority to do it under any circumstance, how do we get engaged in sort of cooperative partnerships, cooperative conservation strategies, and things like that? So it'll be interesting to see, and we expect to see a ruling in those cases. One's called Solinex, and another one's called Moncrief, and we expect to see rulings in those cases later this year. Another thing that's hot right now, earlier this month, the district court in Wyoming issued a fascinating decision in the venting and flaring litigation about how you were involved in this repeal, remand, replace strategy for the venting and flaring rule, the fracking rule, and for the honors valuation rules. You all following that stuff? Do I need to tell jokes? Okay. We have been managing this litigation since the beginning of the Trump administration, where using various parts of federal law, we've been trying to put prior regulations on hold while we repeal them, and then try to replace them with new regulations on the same topic. And we've been engaged in lawsuits in 3 different forums over the legality of being able to do that. So I think that's pretty interesting. Now, I promised Kirby that I wouldn't talk about coal, but I did want to point out that there's a lot of climate change stuff going on in the area of coal, right? A case out of Wyoming called Wright Area took up the issue of whether we could use a perfect substitution model, meaning that if you don't dig the coal at that mine, you could dig it someplace else, and therefore it doesn't have a climate change impact. What do you think the 10th Circuit said about that? Okay, I can see what this is going to be like. And then the real action is this new battle in multiple fronts and multiple jurisdictions over the accounting for the social cost of carbon. Have you heard about that and how you do it? The prior administration came up with something called the Social Cost of Carbon Protocol. There's an executive order that withdrew parts of the ability to use that in executive decision making. But in the meantime, the courts became enamored with the Social Cost of Carbon Protocol, and they they started asking us why we weren't using it. Why wouldn't we use a tool? And we have found it very challenging as lawyers for the federal government to explain to courts why would we not use a tool that we developed when there is maybe not a better tool available. And so I think one of the big challenges is how are we going to deal with issues like this would be a theme for I think all of you to think about. How do you deal with issues that are already embedded in the court's attention and their minds is important, where we might be doing a pivot on our own, and we want to win the cases, right? And so we are involved in multiple lawsuits right now over how to account for social cost of carbon, how to account for downstream combustion, and that applies to oil and gas as well. So that's just a few of the issues that are going on right now in the federal government. And I would really love to spend the time with you. I take my responsibilities as a public servant really seriously. And so I really wanted to make myself available to address questions and issues of concern that you guys might have while I'm here physically. I know there's some. Shoot.
You just talked about the social consequences of fossil fuels. I'd like to see a study done of the social consequences of burning it off.
Say again, please.
I said, you just mentioned that studying the social cost of fossil fuels. I'd like to see a study done on the cost of, okay, no more fossil fuels tomorrow, what will happen?
That's what we've been doing. We basically have been doing a cost-benefit analysis, and we got dinged by a judge in Montana for doing a quantitative analysis of the benefit without doing a quantitative analysis of the cost. So yours is a good point. As a matter of course, we do analyze the benefit of fossil fuel development, but where we're meeting vulnerability is the courts are saying that you're not doing something similar for the cost. And the question is, like what?
Talked about the Roan Plateau. Oh, I'm sorry. All right. You talked about the Roan Plateau down here, and I was involved in that process when it began back in 1999 to 2000. It took 17 years for that, for the first well. I guess they're finally drilling the first well in the area. So it's a 17-year process for the Roan Plateau, and a lot of EISs are still 3, 4, 5 years. If you look at NEPA, I don't think it was contemplated that these studies would take that long. And even EAs, environmental assessments, would take years when they used to take months. Is there any government's doing about accelerating or expediting that process?
My leadership agrees with that point, and in fact, we have a new secretarial order that was issued in August that would require us to get EISs done within 1 calendar year, and the length cannot exceed 150 pages except in situations where the topic is extraordinarily or uniquely complicated. So that's a big change for us because the norm at the Department of the Interior over the years has grown from relatively small NEPA documents to these enormous multi-year undertakings, like, and I'm pretty familiar with the Roan, so I know exactly what you're talking about. So we're still in the process of implementing the new secretarial order. Suffice to say, it's a huge cultural change for the Department of the Interior to try to compress an environmental impact statement into 150 pages because we're used to 150,000 pages, right? So it's going to take some time. And then where I will be really heavily involved is in the marketing because the courts are also used to these very lengthy NEPA documents, and we're just going to have to convince them that we can do really good analysis in shorter documents. Did that answer your question? Sir.
One area that I think is highly relevant to local governments and industry is equal access to justice and the potential reform. I was wondering if you could talk about what the program is and from a legal perspective, do you see any chance for reform or changes to that law?
Maybe you could give us some examples.
When there's lawsuits against the Department of Interior, taxpayers, thank you. When there's lawsuits against the Department of Interior, taxpayers often fund the bill for the legal settlements and or the outcomes. Oftentimes it's NGOs, but not all the time. And there's been a lot of pressure for Department of Interior to reform, to create more transparency around that program, and I wondered if that's something you're working on.
Oh, you're talking about attorney's fees generally. Yeah, it is a worry. I know that there is a pretty significant segment of the public that views what's going on as the phrase they use is sue and settle. Have you all heard that phrase before? It's a worry to me too, because I can tell you there is no Interior Bureau that has an abundance of appropriated funding, right? And frankly, the worst use of appropriated funding is paying for third parties' attorney's fees. And so we do everything we can to minimize those bills. But the fact is that there are laws governing this area, right? And if you lose a case that is governed by EJA, that's what this gentleman's talking about, we're required to pay fees. And so sometimes we just try to make it as cheap as possible.
Matt.
See, I knew there'd be questions. I just got to get people warmed up.
Thank you for coming, Matt. Jeff Comstock from Moffat County. Can you talk a little bit about the SageGrouse issues in the planning process that BLM has undergone right now, where they require a really short time frame for the revision of the EIS, and where the whole process has been and where you see it going in the next few months?
Well, I think the short process times are important because it reflects a recognition that we just did amendments to all these plans a couple of years ago, right? And so I think the public has an expectation, a reasonable one at that the next round of revisions will be done fast, so we can just understand, as a matter of finality, what the lay of the land is, so to speak. I'm not intimately connected to that part, right? I get involved in the marketing phase and the production phase of these documents, but I know that there's a heavy impetus, a heavy directive oversight to say, let's get this new round of amendments done fast, because it feels to me like the public has already experienced a lot of SageGrouse planning, angst, and for another lengthy round seems, almost like like overtime in a football game.
Yes, I'm Bob Arrington from Belmont, Mesa. You mentioned the Wyoming court case that went against the BLM on the thing, but in California they had the same court case where they went the other way. How do you resolve that balance? We embrace the Wyoming one, and we try to minimize the import of the California one. I've had a lot of experience with this particular judge in California. She is also the one that took national jurisdiction over the roadless rule for the Forest Service, so this is nothing new for her. Anybody else have anything they want to ask me about? This is your chance, the man behind the curtain.
Excuse me. Over here.
Yes, sir.
I know you promised Kirby you wouldn't talk about coal, but I'd like you to go back to the coal issue, and if this anti-NIMBY approach is going to have any traction in the future.
What do you mean by that?
Not in my backyard. If you're not going to mine it here, you're going to mine it someplace else. I mean, is this going to have any traction in the future? Are we going to have any chance for viability in this argument?
I'm not sure. A decision that has not been made yet, and so I can't really talk to you all about it, is whether we try to continue with this perfect substitution theory, or we just simply disclose the impacts of mining the coal, right? Which is what the courts are used to. But it's not about NIMBY. It's about us saying, look, there's a market for the coal, right? And just providing more supply doesn't create more of a market. Do you all get that? But there are some who really believe that by adding more supply, you create more market. If only that were so, right? That means you could just make whatever you want, and then all of a sudden people would buy it. You could make as many of them as you wanted to. But the market for coal is what it is, right? And so that's why BLM tried and won at the district court level before Judge Johnson in Wyoming, saying it really doesn't matter where the coal comes from, because we know how much coal is going to be consumed worldwide. But the 10th Circuit said we didn't do a good enough job showing our work of how we reached that conclusion, and then deemed our analysis to be irrational. Which I took personally.
previous administration limited leasing on shale out here, which a lot of people left the area because of the limited leasing. Is there any interest in companies coming in now with this new administration and leasing oil shale?
I haven't heard a pro or con about that yet, to be honest with you. And I would have.
Matt, thanks for being here. John Jacobs with Davis Graham. Back to the venting and flaring case out of the District of Wyoming. Judge Scabdall in that case ruled under APA Section 705 without going through a sort of irreparable harm or preliminary injunction type analysis. Do you have any concerns about that being challenged, or has that been challenged?
Yes, I do, because as the previous questioner mentioned, we have a different approach to 705 from Judge Laporte in California, and I'd like to keep our discretion as wide open as possible to use Section 705, but I'd fully acknowledge for the group, based on what we've seen in publicly available court decisions now, the judiciary is not quite as keen on Section 705 as I am. But I still think it says what it says, right?
Right.
And so what's frustrating, I think, for all of us, is that we think we're on solid statutory ground, and all of a sudden we're told we can't do it. The argument for those of you who are not cursed with being lawyers is that you have to repeal regulations using the same process that you enacted them, but there's this provision of the Administrative Procedures Act. Have you all heard of that? If you have, I'm sorry. That says that you can, stay a regulation while you make changes to it, but the courts have not been. Is this fair to say, John? Not been very receptive to that argument. Come on, this is fun. Go for it.
Yeah, I'm not cursed with being a lawyer, but I do have a question over here.
Yeah.
Do you see any correlation between the 10th Circuit ruling on the hydrofracking appeal and what's happening in the Wyoming Circuit decisions with the venting and flaring rule?
I do, because it's basically the same legal issue that we were just talking about. It's the application and use of this provision, the Administrative Procedures Act. And the courts are wrestling with, do we really want to rule on all these legal questions regarding a rule that's about to be replaced? And so we've done this now 3 times for Office of Natural Resources rule and 2 BLM rules. And bless you. And the courts are all over, the courts are wrestling with the same thing we are. In fact, the Wyoming District Court case starts by saying, by sort of anguishing over what he calls the dysfunctional state of this situation.
Yeah.
And did you read that?
Yeah.
And he says, everybody's trying to do their best with this very uniquely complicated situation. And I think all of us can appreciate the fact that it is tough when you've got all these different regulations that are moving in different directions, and some of them, what's the point of litigating over something that's going to disappear, right? And even Judge Laporte said, no, I'm not going to rule on the validity of the old regulations as part of a challenge to the repeal and the stay of the new ones. So yeah, I think it's all interconnected. I've never thought much about Section 705 of the APA until February of 2017, and then I've been thinking about it a lot every day ever since.
Thank you.
There were more I saw somewhere. Go for it.
I come from agriculture, and I think the industries and probably agriculture themselves have not done a very good job of telling the public of what fossil fuels do for agriculture. Last I looked, I haven't seen any wind or solar powered tractors. We have the world's largest abundant food supply that is relatively cheap, and I always have a hard time figuring out how we're going to quit using fossil fuels like right around the corner, or even 20 years from now. And you read on what Germany did with their green energy initiatives with solar and wind and solar and wind. Their electric bills are so high over there. Why do you think BMW relocated to the U.S.? It's because of energy costs. They call them energy poverty in Germany because I don't know if they subsidize them when you pay more than 10% of your household income for your utility bills. So I know in Mesa County in the winter months, we have probably 30% of people on energy assistance. So as we go down this green energy road and it keeps getting higher and higher, are we going to have 50, 60, 80% of us on energy assistance? I have a problem with all that.
Well, I think it's easier for some of these other places that don't have their own fossil fuel industries to have strong opinions about something they don't have, right? I mean, I have a lot of strong, I mean, it's like there's an old axiom in the government, it's easy to spend other people, it's easy to be generous with other people's money. But, you know, if you're a country that has no fossil fuels, of course you have a strong opinion about it, because there's a basic economic disparity in play here, right? We can supply our own energy with fossil fuels and many other countries can't. Now, the question of whether there are such things as solar tractors, does anybody know that? That's a fascinating question. No, I can't imagine being solar panels on a tractor. I mean, I can imagine it, but it would be like a moving mirror, right? The cows would get very confused. So you other speakers, you owe me one because I'm getting this group warmed up. Anybody else? Go for it.
The theme of the spirit of the theme of the symposium, there's been a lot made about the Department of Interior's move to have more direct communication with local governments and municipalities. Have you seen that from your position, and what does that look like?
Well, I, for one, never stopped. When we were working on the Rome Plateau negotiations, which I worked on for 5 years, we heavily involved Garfield County because what we were going to do there directly affected the future of Garfield County. And so I don't know what other people are doing differently. I worked for state government in my first job. I worked for the Attorney General's office for the state of Idaho, and I was the county government liaison. So it's something I've always personally taken really seriously. So for me, there hasn't been a change. I know that it's just a good business to work closely with state and local partners when you're the federal government. Otherwise you end up in these needless controversies over, say, like roads, roadless areas, hundreds of other things.
Hi, I have a question over here.
Go for it.
I have the good fortune to be a lawyer, and I'm wondering if you could talk a little bit more about the venting and flaring rules and that issue. I'm not very familiar with that, and I'd be curious to hear more just about what happened there.
This is going to sound like a cop-out, and I'm sorry. That one's not my case. I just was using it as a comparator to the others because of the Section 705 issues. So I am not an expert on venting and flaring other than the settlement we did with the Southern Ute Tribe, which is the one place where the venting and flaring rule structure is still in place because we settled that case in 2016. You know, the issue that's really interesting about the Wyoming court's decision in the venting and flaring case is how hard it is to. Here's a takeaway for you. All of the structure of federal environmental law was designed to go forward, not backward. And so when you try to go backward with something under administrative processes, you run into all sorts of challenges because the people who designed it, Congress and the rule makers, that's not what they meant to do, right? And so whenever we find ourselves in a position of saying, well, why can't we just back up? It's because the idea was it's supposed to be hard just to back up. Does that respond to your question at all?
Honestly, I was wondering more, like, who was doing the movement and asking for what?
Oh, in the venting and flaring? Oh, sure. All of the states that regulate this stuff themselves were suing us saying, why are you interfering in our regulation of this area? And then we had other parties defending us saying, we want you to take over for the states. And you can probably guess who was who.
So we believe that there are markets outside of the U.S. for natural gas and even coal, and we've been very supportive of the Jordan Cove export facility. We think that even should we get that built, which we are cautiously optimistic about, that there may be room for more. What do you see is maybe the future of exports of some of our resources?
Well, some of the mines that Interior regulates, almost all of the coal goes abroad, right? And I think that's until, right, this goes back to your point, sir, about, there's this sort of narrative in the global community that isn't really always supported by facts, because they do import our coal, right? They just don't want to talk about it. And so I think there is a pretty robust future, particularly for utility-hungry countries in Asia, right? Who want more electricity for their people, understandably, but don't have any coal.
Or natural gas.
Yeah.
I mean, if we get Jordan Cove accomplished, it may be too little once it's done, and there may be a need for another export facility. What do you see as the future of that from the West Coast?
That's 100% policy, and I would have to defer to others on that. But I'll defend whatever people decide to do. So we have 5 minutes left. 5 minutes left to grill the Fed. No? All right, Kirby? We're done just 5 minutes early. No? We lost him? What we just did is we warmed the audience up for everybody else, so we're good. You guys are awesome. Thank you so much for your thoughtful questions. It's very helpful for me to do my job, to know what's on your minds. If you have other things you want to talk to me about, or maybe if you don't want to speak in front of a group, my direct line at work is area code 303-445-0625. Just give me a call, and we can talk about it. All right? Thanks again for your time.